In this week's episode of the podcast, the means test in bankruptcy.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, and as always, this episode is brought to you by Yesner Law, by my law firm. Now, I do a lot of bankruptcy work in my practice. I do represent both debtors and creditors, so I represent people that owe money, and in some cases, I represent the creditors that are owed the money. Now, in most cases, I'm representing the debtors. Typically, when I'm representing creditors, it may be an individual with a private loan. I do have a couple of friends, a couple of attorney friends that send me to represent different homeowner associations in bankruptcy court. But for the most part, I'm going to be representing the debtors. I'm going to be representing those people who file bankruptcy. Now, interestingly, I started practicing bankruptcy law for the debtor, for the people that owed the money, back in 2004. And something pretty significant in 2005, the Congress passed and the president signed off on the Bankruptcy Abuse Protection and Consumer Protection Act, the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. Gosh, sorry for butchering the name. But most bankruptcy people, insiders, call it BAPCPA, BAPCPA, the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. Now, the purpose of the bankruptcy amendments was because Congress felt that people were taking advantage of filing bankruptcy. Congress thought that the stigma of filing a bankruptcy had decreased to the point that people were filing bankruptcy when they shouldn't be. People were filing bankruptcy when they had the ability to repay their debts. And so in 2005, Congress passed probably what was, since the Bankruptcy Code, a huge overhaul to the bankruptcy laws, and it was called BAPCPA, Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. And so the law did a lot of different things. It was a huge change in the Bankruptcy Code. But what I want to focus on are two things. Number one, the Bankruptcy Code required that people take two courses. One is a consumer education course. So one is a credit counseling course that must be filed prior to filing bankruptcy. Now, for that reason, you couldn't walk into my office today and hope to file a bankruptcy today. I mean, I guess theoretically it's possible. If you walked into my office in the morning and I gave you the information to take the consumer education, the credit counseling course, and you took that course and you came back to my office in the afternoon and we filed it in the afternoon. I guess under that circumstance, yes, you could get a bankruptcy filed in a day. But typically, you would do your credit counseling and then you would come back to me at any point within the next 6 months, within the next 180 days, and I could file your bankruptcy case. But that is a prerequisite. Once your bankruptcy is filed, you have to take a money management course, basically the flip side of the credit counseling course. You have to take a money management course. Now, that has to be taken before you get your discharge. And so typically what I'll do is I'll tell my clients to take it after the meeting of creditors, after the 341 meeting of creditors. That appears to be a good time for them to take it. Most of the money management class companies will then file the certificate automatically with bankruptcy court, so I don't have to do it. And it's a pretty seamless thing for the borrowers. So that was the biggest thing. Now, I've helped a client go through a few of these before, and unfortunately, the purpose of these tests was to make sure that people that shouldn't be filing don't. In other words, if you have the ability to repay your debts, then you're not going to get the certificate from the credit counseling company. They're going to suggest that you enter into some kind of payment plan outside of bankruptcy. Now, as I record this, it is July of 2018, and so now this requirement for credit counseling has been in place for 13 years. I have never, in these past 13 years, had a client go to a credit counseling company and have the credit counseling company say, you don't have to file bankruptcy. You can pay your debts outside of bankruptcy by getting onto this payment plan. I've never had that happen. So the reason for the credit counseling was to ensure that people that could repay their debts without having to file bankruptcy did so. However, in the 13 years since we've had this credit counseling requirement, I've never had one kicked back, where they couldn't file bankruptcy. So it largely just appears to be a rubber stamp. And so I don't know that the requirement of credit counseling really is what Congress intended it to be in practice. That's the first point. The second point is something that I wanted to go into in a little bit more detail. Now, in a previous episode, I talked about Schedules I and J of the Bankruptcy Code. Now, if you want to go listen to that episode, that is episode number 126. 126 of the podcast is an in-depth analysis of Schedule I and J. That's the budget within the Bankruptcy Code. But what I want to talk about is the means test. That was the other big change that was put into place by the amendments in 2005. Now, why do I link the means test to the budget? Well, the means test is itself a type of budget, but there is an art to completing the means test, and there are some nuances to completing the means test. So this is how I describe the means test to my clients if we were in a consultation. Take what you've earned over the last 6 months gross, before expenses. Take what you've earned over the last 6 months, multiply that number by 2, divide it by 12. You'll come out with a number. Now, what is your household size? How many people live in the house? Is it you and a spouse? Is it you and a spouse and a couple of kids? How many people live in the house? What we do is we compare your income, your gross income over the previous 6 months, annualized and then broken down into months. We compare that against the median income as determined by the United States trustee. So each state is different. In Florida, the median income for a household of one is $46,677. 2 people, $57,968. 3 people, $62,912, and 4 people, $74,512. Now, for every person over 4, you add $8,400. So now that's just Florida. If you're listening to this podcast and you live somewhere other than Florida, you need to go find out what the numbers are for your state, for your area where you live. I mean, for example, Hawaii, 1 earner is $64,000, 2 earners is $74,000, 3 people in the house is $94,000, and 4 people in the house is nearly $100,000, significantly more than what Florida says. But here in Florida, we're at $46,600, $57,900, $62,900, and $74,500. So let's say you're a married couple, you both work, and you have 2 kids, and you live in Florida. The median income for a household of 4 is $74,500. Now, let's say that you look at your last 6 months of income and you look at your spouse's last 6 months of income, and you come out with $36,000. And so you annualize that number. 36 times 2 is $72,000. You're a family of 4. The median income, for a family of 4 is $74,512. You're below that. And what that means is that you can file a Chapter 7 case. If you are below the median income, you can file a Chapter 7 case. So again, if your household annual income is $72,000 and you're a family of 4, 2 minor kids, and the median income is $74,000, you're below that, you can file the Chapter 7 case. But what happens if you're above it? What happens if you and your spouse combined, annualized, make over $100,000, let's say, and it's a family of 4, but the median income is $74,512? What do you do? Well, you're over the median income. So what that means is that we have to look at the rest of the means test calculation. Now, what I explain to people is that the means test calculation takes into account some actual expenses, some IRS expenses, and some trustee expenses. Now, in the cases where we have to use the IRS expenses, we may not be able to deduct actual expenses. And so I'll get into some specific examples here, and we'll take a look at it here in a minute as soon as I can pull it up here on my bankruptcy program. So let's say that you're over the median income, and so we have to run the means test. So again, we start with what is your monthly income. And once we've made a determination of what your monthly income is, we then start to deduct expenses. So, for example, we get to deduct. Now, again, we start with gross income, so we don't get to deduct expenses from that. But once we have gross income, we are allowed to deduct some expenses. So we're able to deduct expenses like whatever the IRS says should be our allowance for food, clothing, and other items. Now, for a one-person household, that's $639, but obviously it goes up from there. We can take some additional expenses for food and clothing. We can deduct the amount by which our actual food and clothing expenses exceed the IRS allowance. But if we're going to do that, we need to have some proof. We need to have some receipts. We need to have some documentation that shows why we need to take more than what the IRS allows. And so I think I was talking in the podcast about Schedule I and J, about the budget, about a former client of mine who had a $1,500 food budget because he dated a lot, because he took a lot of women out on dates. Well, unfortunately, I don't know that the trustee would allow us to use that as a deduction on the means test. I think the trustee would successfully argue that we are limited to the IRS standard for food, clothing, and other items. The next thing is we get an allowance per person in the household for medical expenses. And there is a difference between people under 65 and over 65. You get less of a deduction if you're under 65. You get more of a deduction if you're over 65. We then get to take into account actual healthcare expenses. So if you have prescriptions, if you have a medical condition that requires you to have physical therapy, for example, or some other type of monthly prescription or drug, then you would be able to take that actual expense. The next thing we do is we look at the housing and utilities expense. And again, this is what the IRS says. So if your utility expense is more than what the IRS allows, you may be out of luck. Now, the flip side of that is also true. If your actual utility bills are less than what the IRS allows, you're in luck and you get to take a greater deduction, a greater expense deduction. Now, that doesn't mean that you should reduce or exceed the allowance there given by the IRS. But certainly, if you can save a couple of bucks by some utility, electricity, turning off lights and using less, then certainly if your actual utility expenses are less than what the IRS allows, you still get to deduct the IRS expense, the more money. The next thing that we look at are housing expenses. Now, this is an area where we do get to use the actual expense. The IRS, the means test rather, will require that we deduct the expense that the IRS allows for mortgage payments. However, if your mortgage payments happen to be more, I've always argued that we can take that additional payment. Now, I know that some trustees, some U.S. trustees, are arguing that we should only be allowed to take the IRS-related expense, but I think that's kind of a bogus argument, and I would think that we could successfully argue that you can take your actual housing expense, so long as you're paying the expense. If you're paying more than what the mortgage payment allows every month, then I think we have an issue. But if you're making your regular mortgage payments and you want to keep your house and it's homestead property, I think we'd be okay with that. I have a case right now, I'm looking at the means test where we've also deducted the homeowner association assessments, and I think that's an area where you can deduct the actual homeowner association expense. We then get deductions for cars. Now, here's where it gets a little bit interesting. There's two different types of car expenses. One is the expense of ownership, and one is the expense of maintenance. And so you get to take the maintenance expense regardless, and that's for things like oil changes and tire rotations and gas and all the things you need to do to keep your car running. The ownership expense is the expense that you pay for your car payment. Now, here's what the courts have come out and said. If you do not have a car payment, you do not get to take this expense. But if you do have a car payment, you get to take this expense deduction regardless of what your car payment is. So, for example, if the IRS says your car payment should be $517 and your car payment is actually $600, I think the IRS and the bankruptcy trustee are successfully going to argue your deduction for this expense is $517. However, I think the reverse is also true. If your car payment is $400 and the IRS allows an expense of $517, which means the trustee allows an expense of $517, then even though you actually pay less, I think you get to deduct more. You also get a deduction for public transportation expense and any additional transportation expense that you can prove that you have receipts for. The next group of expenses, taxes. This is actual. What do you actually pay in taxes from your paycheck every month? Now, I've seen the trustee successfully argue that if you over withhold, that should be adjusted downward. But at least for purposes of this podcast, what do you take for taxes? What kind of involuntary deductions are taken from your paycheck? So mandatory retirement plans, union dues, uniform dues. Do you have term life insurance that comes out of your paycheck? Do you have court-ordered payments like alimony, child support, and other payments that are non-dischargeable? Do you have education expenses for a physically or mentally challenged child? So do you have educational expenses above and beyond because your child has some type of a learning disability? Do you have child care expenses like babysitting, daycare, nursery, preschool? Do you have telephone communication expenses that are related to your welfare or the welfare of your dependents? So again, I think this might be a situation where you have an elderly mother, father, grandmother, grandfather, and you need a cell phone to be in communication with them. I think this would be a situation where you have a special needs child, a child with a learning disability, and you need to be in communication with them. If that's the case, then you get to take that phone expense from your means test analysis. Then we have, what do you actually pay in health insurance, disability insurance, or in a health savings account? Do you pay for the care and support of an elderly person or a chronically ill person or a disabled person? You get to take that expense. Protection against family violence. This is a little strange one, but I would assume that if there's an issue with family violence, maybe we can try to include here your ADT payment or the payment for your alarm system, although I don't know that the trustee would like that. Trustee would probably challenge us on that. Do you have educational expenses for dependent children less than 18? I mean, I can tell you now, I've got 2 young kids, and the price that we pay for daycare, for after-hours care is extraordinary. However, this expense category limits the educational expenses for a dependent child to up to $160.42 per child. Now, again, I'm recording this in July of 2018, probably come out in August of 2018. These numbers are adjusted on a regular basis. So when you're listening to this, I would suggest checking out the means test or going to a bankruptcy attorney. Some of these number limits that I'm discussing may be more or less depending on what's happened with the Bankruptcy Code. Plus, the means test also allows you to take charitable contributions like the budget, like Schedule I and J. The government will let you tithe and file bankruptcy, although you're probably going to have to produce expenses to show that that's the case. Then we get to deduct payments for priority claims. We get to deduct what we anticipate the Chapter 13 administrative expenses would be, and we get to deduct anything else that you may want to deduct, qualified retirement deductions, and then anything else that you think might apply that the trustee will challenge it if you don't have the backup to support those things. So here's what we do. We take a look at what is your monthly income, gross, before expenses, and then we deduct all of these expenses that I've just discussed, whether they're actual expenses, whether they're IRS allowed expenses, meaning trustee allowed expenses. The means test relies heavily on what the IRS says are reasonable expenses, so we deduct those expenses. And then at the end of this analysis, we get a number. Now, if that number is less than, say, $100 to $150, now it's very factually dependent, depends on how many people in the house, depends on the income, depends on all that kind of stuff. But generally, if we get a number that's around 100 to 150 or less, it is possible that the Bankruptcy Code will say you still don't have enough to fund a repayment plan, a Chapter 13 payment plan. And even though your median income, your actual income is greater than your median income, you can still file a Chapter 7 case. If we run the means test and that number ends up being 200 or 250, or let's say for purposes of this example, you run the means test and you get a $300 number. What that means is that the trustee is saying you can afford to pay $300 a month towards your Chapter 13 plan, towards your unsecured creditors. $300 a month over a 60-month plan, you can pay $18,000 over the life of the plan to your unsecured creditors. If you have $180,000 in debt, you're paying back 10%. If you have $36,000 in debt, you're paying back 50%. If you have $18,000 in debt, you're paying back 100%. And that's how the means test works. So obviously there is an art to filling this out, because if you're first we need to make sure you're calculating your income correctly. There may be an issue if you have bonuses in the last 6 months. Your income may be artificially inflated. If you took a pay raise or a pay cut, your income may be artificially inflated or deflated. And so there is an art to coming up with your income, although really all it is looking at the pay stubs and then annualizing that figure. It's simply a math equation. There is also an art to determining which expenses you're going to take. Are you going to get a challenge from the bankruptcy trustee by taking a certain expense? If that's the case, you need to talk about that with your bankruptcy attorney before completing the means test. So there is an art, there is a science to filling out this form. You will get challenged by the trustee if you fill it out wrong. I've had situations where I've challenged or the trustees challenged me on some of my numbers, and we either have to fix the means test to include those numbers, or we have to take it to the judge and let the judge make a decision. And so what I would say is the means test is not something that you should fill out on your own. You should definitely have someone who understands it fill it out for you, because if you get it wrong, let's say you should have filled it out so that your monthly disposable income was only $300 a month, but because you filled it out wrong, it showed your monthly disposable income was $500 or $600 a month. Now you're going to have to pay more than what you would have had to pay otherwise. Or the reverse. Let's say it came out to $300 a month is what your monthly disposable income should have been, but whoever prepared it wrong, and it says $100 a month. Well, you're going to get challenged by the trustee, and you're going to get a huge jump in what your Chapter 13 plan payment should have been because you filled out your means test wrong. So this may be one of those areas where I say, even though you can do it yourself, I would highly, highly suggest that you contact a bankruptcy attorney to help you complete and fill out the means test and file your bankruptcy. So I apologize if I got a little bit into the weeds in this episode. I wanted to give you a little bit of insight into what the means test is. It is basically the determination as to whether you can file Chapter 7 or Chapter 13, and then if you have to file a Chapter 13, how much do you have to pay to your unsecured creditors? That was one of the biggest changes provided by the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, the BAPCPA amendments. And so thank you again for listening to this week's episode. I would really appreciate if you guys could share or subscribe to the podcast. You'll get all the updates as they come out every Thursday. The podcast numbers are still going up, so I very much appreciate you all listening. Please check us out on Facebook or on the internet to keep up with what's going on over here at Yesner Law. I appreciate you listening, and we'll talk to you in next week's episode of the Crushing Debt podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.